men and folks from the LGBTQ community or even married women don't necessarily have a path in case they are victims of sexual offenses to seek justice.
377 has been completely deleted. You have taken away a plank which was available easily. That is true.
A adult man is a victim of rape. And the section for rape as it exists currently in the BNS does not...
It is not gender neutral.
It is not gender neutral. It doesn't envision men as...
It requires the victim to be a girl.
Yes.
Or a lady. The colonial kind of, the burden which this country was still carrying on, to a certain extent, has been shrugged off. The criminal laws which have been in vogue in this country for more than 150 years, that has been the criminal administration of justice. So therefore it is very difficult to shrug everything off. The only thing is that with the tremendous burden of cases on the courts at every level, to what extent they are able to be on the right side of these timelines is something which we will have to see.
Hi everyone, my name is Ajoy Sinha. I'm a journalist with the Indian Express, and with me is former Chief Justice of India, Lalit. Thank you for speaking with us, sir. We're speaking about the new criminal laws that were passed on July 1st, 2024, or rather came into force on July 1st, 2024. The Bhartiya Nyay Sanhita, the Bhartiya Nyaya Suraksha Sanhita, and the Bhartiya Sakshya Adhiniyam. Just to start off with, sir, on a lighter vein, how has retirement been treating you? You're a little bit away from the Supreme Court now. You have got a little bit of a distance. Has it been going well? Has everything been fine?
It has been going perfectly well.
Yeah. Picked up any new hobbies that you'd like to share with the world? Or is that?
Not exactly. The same old hobbies are continuing. The only thing, the distinction or difference is that I have been teaching law now since my retirement. I have been teaching at various law schools, take regular courses. So therefore, that's one dimension which got added completely after retirement.
Now you're dealing with the law students of them all.
Yes.
They've been fine. They've been testing your patience.
Not at all. Not at all. It's in fact has been very, very engaging experience.
I'm glad to hear that, sir.
Yes.
So just to kick off with the interview itself, the 3 new laws have been pitched and portrayed as a decolonization effort of moving away from the shadow of colonialism and everything that came with it. How do these laws purport to achieve this end, and do they actually do so in reality?
Partly yes, because say offense like sedition. Now, sedition was principally an offense of the colonizers to control what is called the natives or the subjects. So therefore, any law which was designed to curb the voice of protest would naturally have that kind of flavor where you are trying to rule over your subjects. So therefore, sedition, for instance, as a very famous trial was Tilak's trial, Lokmanya Bal Gangadhar Tilak's trial. He was charged for the offense of sedition and was sentenced for 6 years. Correct. So therefore, his address before the then Bombay High Court, because it was holding sessions in those days. So that is something which actually what he said is that as a journalist, I have every right to criticize the policies of the government. So therefore, that's my right. Now that is something which was denied in what is called pre-independence days. We of course continued with the same set of laws, same set of provisions, but then in Kedarnath Singh, the Supreme Court had an occasion to consider what are the intricacies of that law. So Supreme Court ruled that if it is pure criticism of the policies of the government, then there is no offense. Unfortunately, what happened is that the offense still continued to be on the statute book. So therefore, that something got deleted. Now, you can say that very well. The colonial kind of, the burden which this country was still carrying on, to a certain extent, has been shrugged off. So therefore, that's one part.
Right.
But major part is, see, what the criminal laws which have been in vogue in this country for more than 150 years, that has been our heritage, that has been our ethos, that has been the criminal administration of justice. So therefore, it is very difficult to shrug everything off.
Right.
Correct. So therefore, partly it has been retained, partly some of the provisions like this have been taken off the statute.
Right.
Or there have been amendments so far as the other parts are concerned. Now, take for instance 303 of the old IPC, which used to be there as part of the statute book. According to it, if a person was actually undergoing a life imprisonment in connection with an offense of, say, murder, he was already undergoing a life sentence, and while undergoing life sentence, he commits another murder.
Yeah.
Then the law obliged the courts to give him death sentence.
Oh,
So
it
the
was mandated.
court shall pass order of death sentence. In one of the judgments, the Supreme Court said that how can you take away the discretion of the court?
Right.
So the court must have the discretion in the final analysis, even to award life sentence in such matter. Now, the new law gives life sentence as one of the options to the court. So these are some of the amendments which have been effected to keep the entire statute in sync with the modern times.
Right. Is there anything that the new laws missed? Do you think there are any colonial holdovers that still have made their way into the new laws in any way?
Not to my mind. Not colonial hold, but the entire administration of criminal justice, which was outlined as a result of these three legislations, erstwhile legislations. So the perimeter of that has been maintained even in the new laws.
Okay. While we're briefly touching upon the subject of sedition, as people might know, the offense of sedition has been done away with in the form that we knew it in. And a lot of people are pointing at section 152, the Deshdrohi provision, or rather the Deshdrohi offense, and have said that this is a facelift. This is the new. This is what's come in instead now. Are there any concerns that this new law could be used to curb dissent or used to curb, or whether the same concerns that sedition carried with it are now carried with this new law?
No, not at all. As I told you, see, the very fact that, this sedition as a tool used to be used by the rulers to curb the voice of protest. Correct, every time.
Yes.
So therefore, take for instance Tilak's trial. The moment he criticized the policies of the government, he was slapped with that particular charge and finally sentenced and sent for 6 years. The idea was to remove all such people from the active political scenario or the scene. Now, in a free country, you can't equate that kind of logic here. Correct. So therefore, in theory, what this offense now percolates down, even in Kedarnath Singh, what the court had said was, if there be any incitement to people or section of people to take up armed rebellion against the government by law established, then it would amount to sedition. But mere criticism of the policies of the government would not amount to sedition. So what is now put is in the distilled form. So therefore, whatever is incitement is certainly part of that, because going by the law laid down by the Supreme Court, this is exactly what the new law seeks to achieve.
So should the Supreme Court keep hearing the case on the constitutionality of sedition? Should that case be set aside at this point?
Not necessarily, because what happens is the normal principle of General Clauses Act and any act which comes into effect as a new legislation will always say what is called repeal and savings. The old law gets repealed, but whatever be the right or liability incurred under the old law, or a right which accrues in favor of a person, will normally continue. So therefore, supposing in case there has been an instance of, say, something which has happened and which is subject matter of a charge,
Right.
then that will continue. So therefore, that is exactly why. So therefore, constitutionality of that particular matter, the Supreme Court will have to now actually consider whether, number one, to rule upon that, or number two, in the change scenario, whether is it really required or necessary to sort of engage the attention on that count. But that's entirely for the court to consider in the given set of facts and circumstances.
Of course. So then moving on to the broad question of the Evidence Act. The Bhartiya Sakshya Adhiniyam has introduced a series of provisions about electronic records and how evidence can now be submitted electronically. But aside from that, it seems that for the large part, the Evidence Act 1872 and the BSA now seem to be largely the same, even though that there have been calls for reforms with regards to the evidence law. The Law Commission has also published a couple of reports on the subject. Is there a reason, do you think, that evidence law hasn't received the same overhaul, or rather the same facelift that the other two acts have?
Again, evidence law is essentially in the nature of what? That whether a particular part should be looked into or not, and whether looked into with what kind of vigor. Now, take for instance, when we introduced into our criminal jurisprudence something called, say, dowry death or harassment of a woman at the matrimonial place, we incorporated two ideas which are 113A and 113B. So therefore, the court may presume, the court shall presume. Now, these are rules of evidence which you introduce in your evidence code. Why? Because depending upon the exigencies of the situation, the circumstances, whatever the society calls for it. So therefore, you introduce what is called new rule of evidence. Correct. Okay. So therefore, there are certain provisions in which this will be required. Now, over a period of time, we have been making these changes. Now, for instance, electronic evidence. Electronic evidence as ruled by the Supreme Court in that P.V. Anwar's case, and finally Arjun Pandit Rao, has to be introduced only subject to certain things. So if you fall in that particular criteria or category, then only your electronic evidence will be allowed to be received on record. Now, that is something which the Supreme Court had ruled, has become part of our jurisprudence. So therefore, everything has been continued.
So it's a gradual sort of
it's
growth.
right. It's not something which becomes, shutters down attitude on one single day. It's a gradual process which keeps going on. For instance, expert evidence. To what extent do you rely on that expert evidence? So therefore, who shall be called as expert evidence? Whether is it simply fingerprint, or is it something greater than that? So therefore, these are some of the matters which are certainly part of the what is your evidence law.
Right. Seeing as we're already talking about the nitty-gritties of the criminal trial process, the BNSS has introduced comprehensive timelines for each and every stage of a criminal trial, from how long it should take for an investigation to be completed, for how long it takes for a judgment to be delivered, and for the sentence to be delivered after that. Are these timelines restrictive? Are they realistic for judges on the ground to actually abide by on a case-to-case basis?
They can certainly be realistic. Now, take for instance, if the investigation has to be completed within a particular level of time, if you go by the logic of 167(2), the old law, then in normal cases, 60 or 90 days would be the period of custody, which is the maximum, within which the idea was that the investigation must be complete. If your investigation doesn't get completed, then the accused would get a right to be released on statutory bail. Now, normally what used to happen is that, I won't say it was in order to defeat the right of the accused, but there would be, supposing if the first charge sheet is filed and the police is still continuing with the investigation, how long can they continue? So therefore, these are now some of the fetters have been put that very well. You must take it. You can continue with the investigation only with the consent or with the permission of the court. Again, there has to be some kind of restriction which has been put. Similarly, charge has to be leveled within a particular period. Then thereafter, the trial has to be undertaken within a particular period. These timelines, I won't say they are non-realistic. They are definitely realistic. The only thing is that with the tremendous burden of cases on the courts at every level,
Right.
to what extent they are able to be on the right side of these timelines is something which we will have to see. Yes.
And if we're seeing that in the hypothetical where we're seeing that they're not always on the right side of these timelines, so that this becomes an issue in the future, how do we address that?
Now, even in the old code, there used to be provisions like if your trial is not over within so and so period, and if it has eaten up something like more than half the period, which is the maximum sentence, then the person could be released on bail. That would give him a right to be released on bail. So, if all of those ideas are still there, correct. So, therefore, if there be non-adherence to any timeline, the resultant or the consequential empowerment so far as the accused is concerned is also there.
Right. We briefly touched upon the 60-90 days in the old criminal procedure law. Currently, there is a conversation going around about how the amount of time an accused can spend in police custody seems to have been increased under the BNSS, because if the magistrate does allow the investigation to take longer than that initial 15 days, the provision that has said that the accused will not be in police custody during that time seems to have been removed, or rather that phrase has been removed.
No, it hasn't been removed as such. See, under the old law, let's put it this way, under 167(2), the maximum police custody could be for 15 days. But it was also coming with a rider. That first 15 days, in that window alone there can be police custody.
Okay.
Now, if a person is in custody for say 60 days, out of those 60 days, the police custody could be only in first 15 days.
Correct.
After the expiry of that 15-day window, then the person concerned, his police custody must now get changed to what is called magisterial custody or judicial custody. So he would no longer be in the custody of the police.
So you're saying even under the current law, past those 15 days?
No. In the current law, instead of first 15 synchronizing with first 15 days police custody, now it can actually be in that window first 40 days.
Okay.
Out of 40 days, there can be 15 days, either in whole or in parts.
Right.
Now, why has it been made? Now, take for instance, if there be a crime in which one accused is involved, and there could be other accused also who are completely at large, and you interrogated somebody in police custody, and then you get the custody of the other two accused maybe after 15 days. And in their interrogation, some of the issues or some of the facets of the matter may get surfaced, which you would like to put it to this first accused. But unfortunately, 15 days getting over, so therefore you can never have the police custody. So therefore now the new code gives you additional time, that of course your limitation shall be 15 days, but not exactly synchronizing with first 15 days of custody, but it could be any time during that window of 40 days.
But doesn't that non-synchronous custody possibly open the doors to a certain level of harassment where an accused person is asked to keep coming back to the police, or the police keep calling them back?
No, accused, the moment he is in police custody, he will always be in police custody.
But you're
So
saying those 15 days can be
15 days,
non-synchronous.
no, from that police custody, it could be magisterial custody.
Okay.
And magisterial custody again getting back into police custody. So therefore there is possibility. For instance, supposing in a heinous crime, say murder crime, correct. Now the investigation takes at least about 60 to 90 days, going by the levels of the period which has been given to you. At that juncture, first 15 days are over and you may have taken the custody of that particular accused for 8 days. So you still have 15 minus 8, 7 days of remainder chance to have him in police custody. But after that, supposing if the public prosecutor were to say that we don't really require his custody now, but I will renew the prayer after some time. Now he has that chance to renew the prayer and then seek that instead of magisterial custody, allow the police the further custody for about 7 days or 8 days.
So it does shift the balance of convenience.
Of course, yes. That is essentially for the purposes of investigation. And merely because the police are demanding that doesn't mean that the custody gets granted.
Right.
The ultimate arbiter or the decision maker is the magistrate.
Then moving to a different provision of the BNS. We had conversations about sedition, about Deshthroh now. Section 197, which punishes the publishing of misleading or false information. At least that's one of the things that Section 197 does. There are some concerns that the 4 things that it punishes are slightly broadly phrased, and a lot of acts can be sort of slotted in there. And especially in a world that's dominated by social media and dominated by online content and things being published online, there are concerns about vagueness and overbroadness there. Do you think?
I don't think these concerns are, of course, yes, everybody has a right to project a particular viewpoint.
Right.
But at the same time, at the root of it is what? That do I have a right to publish something which is utter falsehood?
Of course.
So you can't have that. So maybe then I may not have checked the real affairs. So I published something without actually sort of bestowing attention, without even thinking twice. Now that is something which as a society, perhaps I think if you want to have those good standards of behavior governance, then perhaps yes. But in a given situation, the court will consider whether the fact situation demands it or deserves it or not. So therefore it will be done. Maybe over a period of time, the court may consider diluting the provisions, the rigor of that. So it's up to the courts.
Right. So we've had conversations about what's in the BNS, what's in the BNSS. I want to shift the subject a little bit to something that is no longer in the BNS, namely Section 377, which, as we know, after the Navteej Singh Johar judgment, was essentially read down to only apply to non-consensual sexual offenses. And because the provision was phrased in a gender-neutral manner, it gave a path for men and folks from the LGBTQ community to file cases and to seek relief and seek justice in case they were victims of sexual offenses. But now that section has been completely removed from the BNS, and there are concerns that men and folks from the LGBTQ community, or even married women, as a case came up recently at the High Court level, don't necessarily have a path in case they are victims of sexual offenses to seek justice. Is there a route for these groups of people to see in case they are victims of such offenses?
See, what you say is right. 377 has been completely deleted. So, what was the essential idea? Nas Foundation and so many judgments which are essentially, coming from Delhi High Court, the division bench which was Chief Justice Ajit Shah and then Muralidhar's bench. Consensual relationship, even that kind of, could still be considered to be an offense.
Right.
Correct. So therefore, what you are now trying to do is you are trying to do away with that particular part. So therefore, when there are two consenting
the court
adults,
did away with that.
consenting adults, so therefore court did away with that, correct? Now this is exactly what I said. So something which hasn't received the attention of the court or the approval of the court, something like 303, you insert or introduce life sentence as one of the options. Similarly, if the court is something which has ruled against the constitutionality of this kind of provision, so therefore what the lawmakers have now done is they have done away with this particular provision altogether, so that there is, even in case of consenting adults, it could never be taken to be an offense. Now what you are suggesting is, supposing if one person is actually in the nature of a victim, then whether there has been a platform has been taken away from him or her to agitate that particular part. Now supposing in case there is any such person a victim, there are enough number of provisions under the IPC where the issue can still be ventilated. So it's not necessary that only 377 was the plank which was available.
But right now under the BNS, it's phrased as offences against women and children, and even the sections themselves seem to only consider
now take
women
for
as
instance,
possible victims.
a minor girl, if she was to be procured, correct, for the purposes of prostitution or something which will be completely against her will, against her consent.
Of course.
Now, similarly, even a boy who has been procured like this, it becomes an offense under the new law.
Yeah.
So therefore, there are enough number of provisions which will take care.
But there will,
if you are looking at it from the perspective of a victim. Correct.
So, but there again, we're speaking about minors. But what about, hypothetically, forget 377 for a second. A adult man is a victim of rape. And the section for rape as it exists currently in the BNS does not...
It is not gender neutral.
It is not gender neutral. It doesn't envision men as...
It requires the victim to be a girl.
Yes.
Or a lady.
So then what are the options available for
there are enough number of offences, you can still sort of pinpoint that.
But none of them carry the same punishment or the rigor that
maybe yes, you are right on that score, that perhaps I think the rigor of 377 which was earlier there, perhaps the lawmakers should have then made a distinction that 377, to the extent when it comes to consenting adults, the rigor should be watered down. But when it comes to somebody who is a victim of the entire mechanism, then 377 be retained in its original form. Correct.
Okay.
According to me, it makes no difference. There are enough number of provisions which can still be sort of, put the finger on, and you can still sort of, then come out with.
But there is an imbalance, isn't there? In terms of
you have taken away a plank which was available easily. That is true.
Okay. Yeah. Then coming back to bail a little bit, you mentioned first-time offenders. You mentioned the mandatory bail once half the sentence has been completed, and recently, I believe the Supreme Court in August decided, with agreement from the government and in discussion with the government, decided to apply those provisions retrospectively, namely the provisions regarding first-time offenders and releasing them on bail after they've completed a third of the sentence. Now, the provision itself doesn't say anything about retrospective application. Does this mean that if the government and the court just come to a consensus in court, they can apply any provision in the BNS or the BNSS retrospectively, whether or not that was the intent of the legislature?
Again, that's a very, very, it's a debatable issue. Number one, according to the Constitution, you cannot ex post facto increase the punishment for an offense which was committed earlier, or prescribe a punishment where it was not there at all. Correct. So therefore, you cannot have any prescription which will be to the prejudice of the accused. Correct.
But to their benefit.
Now here the provisions are not to the prejudice of the accused, they are to the advantage of the accused.
Okay.
Correct. So therefore, if they are to the advantage of the accused, that is to say, under the old regime, I could not be released on bail, but now presently there is a clear provision which points in one direction that perhaps I think in a given situation, the accused may have a right to be released on bail. So therefore, the provision is more advantageous. Now, there are enough number of cases on the point. The case law which has developed is that if it is advantageous to the accused, then we can certainly sort of, then take a look at that, apply it to the extent possible.
Regardless, it seems to have come as a relief to under trials across the country.
Yes,
that decision.
yes, it certainly is.
Yes. But sticking to that same provision, the BNSS also introduces tweaks that law when it comes to the mandatory release for other offenders, for non-first time offenders, in the sense that if there is more than one case or if they're accused of more than one offense, then that provision no longer applies to them. They cannot be released immediately, automatically after half their sentence gets over. Will this not add to the problem of the booming under trial
proposition? Not necessarily.
proposition?
Again, the same thing. A provision which is advantageous, even in new law, you can certainly rely on that. But if the new provisions are more disadvantageous, then you can still say that very well, so far as my problem is concerned or the instant matter is concerned, it should be governed by the principles which were in existence when the offense was committed.
But that's not a personal choice, though. It's a question of when the offense was committed.
Correct. So, but this can certainly be agitated before the court, that you cannot actually put me in the stricter regime which was not in existence when the offense got committed.
Right.
So therefore, that's why I said I made a distinction. Something which is onerous, the accused can take advantage.
Okay.
Something, the provision which becomes more relaxed, more advantageous, the court can still apply that so far as the accused is concerned.
So are you saying that in a case committed, for an offense committed after July 1st, 2024, the court can still choose to apply the...
No. If the offense is committed after 1st of July, then yes, you must fall under the new regime.
Right.
There is no escape. I am saying that if the offense was committed earlier and now the new regime is more advantageous, then you can still rely on the new regime. If the new regime is less advantageous, then the accused can still say that very well, my case should be governed by the erstwhile regime.
Okay. So then, just purely looking ahead on that subject, will this not increase the number of under trials?
Why?
Because not often is a person charged with a single offense. There are usually multiple offenses against a person when that case goes to trial.
But it will all depend upon when the offense was committed. When the offense was committed. So therefore, it's not something which, if it becomes a continuous course of action, then you can still say that very well his case must be governed by the new regime. So everything depends upon everything. So therefore, your idea is a very, very hypothetical idea. Okay. Let's put it this way. The offense was committed before 1st of July 2024. Then the clearest form is that it was before the introduction of this new. Now, if the new regime is somewhat more onerous, then the person can say that my case must be governed by the erstwhile regime. Correct?
Correct.
But if the new law is more relaxed or gives him better advantages, then he can still rely on that as I said, that the courts may grant him benefit. So therefore, that depends upon the fact situation.
But it's not purely a hypothetical. Like going ahead, people are going to be accused of multiple offenses. And
if they are going to be accused of multiple offenses, which means that the offense is registered or committed after 1st of July.
Yes.
So therefore, it will always be. So therefore, we are now part of the new regime. So new regime has to be given the full play.
Got it. There are a couple of definitions or new crimes that have been introduced in the BNS, specifically with regards to organized crime and terrorist acts. These are subjects that have been covered by other legislations, the MOCOCA, the UAPA, and the definitions also share a lot of similarities with those acts. but there don't seem to be quite too many guiding principles on which act to apply when an offense is committed. Whether in case there is a terrorist act committed, should the UAP apply to that situation, or should the new BNS offense apply to that situation? Where will these guiding principles come from for police officers on which offense to apply when?
I'll give the answer in two different compartments. Number one, now there are certain state legislation, say for instance Maharashtra Organized Crimes Act, which you said Makoka. The same model gets repeated in some of the other states like Gujarat, Rajasthan, Karnataka, Madhya Pradesh. So therefore there are about 6 or 7 states where that same model is there, including NCTO telling. Now that comes with not just defining what is organized crime, but also creating a separate regime. In a sense, a police officer can record the confession. Such a recording of confession by a police officer becomes admissible. It can be relied upon. The police officer also has a right to intercept the conversation, of course subject to taking clearance from the appropriate authority. So these are some of the ideas which are there in MCOC. Correct. Now what has happened in BNS is you have simply taken the definition section, said that this shall be organized crime, this shall be the punishment. But all these appendages, that is to say the police officer getting the right to record confession, such confession being admissible, such confession could be read against the co-accused, and also the second part, that interception of a telecommunication. All of this is not part of any procedural law now under BNSS. So there are two things which can emerge. Number one, very well, today the parliament thinks that the existing regime where the police officer must be under a restriction not to record the confession, or if at all the confession has to be recorded, it must be before the magistrate alone. Correct. According to the parliament, is good enough for organized crime. Correct. So therefore we don't require so many sharp teeth.
Okay.
So therefore organized crime can still be controlled by the normal police machinery. Very well. This is one part. Now the second part, what you say is that there may be slight overlap between the definition of terrorist law under this and something which comes under UAPA as well. But that is not something for the first time. It has always been happening. Now take for instance, if you use explosive substance for committing a law, committing an offense, you can be charged under Explosive Substances Act and principally under BNS also. Okay. If you have an arms, you can be charged under Arms Act and so and so, so and so. So therefore the very same act or the very same quote unquote act complained of can fall under many legislations. So therefore there is no distinction or difference on that count.
Okay. You're saying this is a problem that we have overcome.
This is something which our jurisprudence has actually sort of accepted it and has lived with that.
Okay.
Now in good old days there could be an offense under TADA, there could be an offense under 302. So there would be separate punishments, that for offense under TADA 3 there is a punishment, for offense under 302 there is a punishment, for offense under section 5 possessing unauthorized arms there could be punishment, under the Arms Act also there could be punishment. So therefore yes, this kind of overlap is something which we have accepted all through.
Okay. So then I'll get my final question of this interview. My only question is, do you think the new criminal laws would have benefited from a gradual rollout as opposed to a new set of 3 acts? Do you think this could have been done through a series of amendments instead? Or is there a benefit to having a timeline or a point in time where you say this is where everything changed?
I don't think so, because the reason, as I gave you the examples of say 113A, 113B, correct? The kind of modifications which were done so far as the principal offense of 376 is concerned. Now, 376, which is a rape offense, is a genus. The species are slightly different. Now, take for instance, if there be gang rape, if there be rape by a person in authority, if there be rape on a minor, these are what is called aggravated forms of the offense of rape. Now, there have always been modification to keep the matters in check, to be on the right side of so far as times and societal needs are concerned. Now, last amendment or something which came up was that the punishment could be till the last breath of the man.
Okay.
So therefore, when you say life sentence, there has been a jurisprudence which got developed way back, Gopal Godse's case, that life sentence means till the last breath of your life. But there is a commuting power which is given to the executive, which, going by Maruram law, could be exercised only after 14 years of actual imprisonment. So theoretically, a person could be released immediately after 14 years of actual sentence. Now, there has been a judgment by the Supreme Court in that Swami Shraddhanand and then V. Hariyar saying that yes, their courts can also impose a sentence. Now, the legislature doesn't want the matter to be sort of, kept in doubt. So it has said that so far as rapes are concerned, if it is a minor's rape, then it shall be till the last breath of that offender. Now, all of these ideas, they're not coming all through, all of a sudden. These are gradual changes in our criminal jurisprudence which have taken place. So all of it is now part of the new BNS.
Okay. So
therefore, it's a gradual process itself which was undertaken by the legislature, the parliament, over a period of time.
And this is the end game of that. It's a comprehensive...
I can't say end game, but yes, this is something which is now the final codification and sort of, the systematic way of doing it. Yes.
Okay. Thank you so much, sir.
Thank you.
This was everything.
Thank you so much. Thank you.